There has been a lot of uproar, understandably, over the tragic death of Harry Dunn back in 2019. But a lot of this uproar and a lot of the comments are not necessarily founded in the reality of international law. It is unambiguous that the driver of the car is in fact entitled to diplomatic immunity ratione personae, and as of the law at the time, she cannot be detained or arrested by the British police. Now, of course, it's possible for the US to waive her immunity and send her to the UK for prosecution, but and the US has chosen not to do so, and because the US has chosen not to waive that immunity, she unambiguously has the immunity. And this is based on the stipulations of the Vienna Convention on Diplomatic Relations, particularly Articles 29 and 37, which make it abundantly clear that not just the diplomatic agents themselves, but also their spouses and their family members are entitled to immunity. Now, the controversy came because of the waiver of immunity that employees at RAF Croton were required to sign, and the husband did sign the waiver. But the scope of the waiver only extended to himself and did not apply to the spouse, and this has been made very clear by the UK's Foreign Secretary, Dominic Raab. And Article 29 of the Vienna Convention is very, very clear. It says that the person of a diplomatic agent shall be inviolable, and that he shall not be liable to any form of arrest or detention. This is absolute, and although there are many treaties in international law that have not been signed or ratified by many countries, most particularly troublesome or most particularly controversial is the fact that a lot of countries have not signed or ratified the Declaration of Compulsory Jurisdiction of the International Court of Justice, but the Vienna Convention is very popular, and the UK and the US have definitely both signed it. But of course you might say, hang on a second, the driver was not, in fact, a diplomatic agent. She was the spouse of one, and so she wouldn't be covered by 29. Well, that's true, which is why we also have Article 37. 37 makes it clear that the members of the family of a diplomatic agent forming part of his household shall, if they are not nationals of the receiving state, which she was not a national of the UK, enjoy the privileges and immunities specified in Articles 29 through 36. And there you have it. It's not just the individual diplomat, but also the family thereof that is covered by this immunity. What's very important to remember, though, is that this immunity is immunity ratione personae, which means that it only applies procedurally. It's only able to stop the process of justice and does not exonerate the accused. Now, what this means is that if she returns to the UK in any other circumstance as a civilian, she would in fact be liable to arrest or detention. And this is because this immunity is not immunity ratione materiae, which covers everything done in the course of one's duties as a diplomat or as a government agent. And immunity ratione materiae does in fact exonerate the individual who is accused of wrongdoing. But it would be a very, very tenuous argument, or an impossible and unconvincing argument to make that driving on the wrong side of the street is something that has to be done in the course of one's duties as a diplomat's spouse. That would not fly. Which means that she is no longer entitled to this immunity. Which brings up two possible questions. Number one, can she ever return to the UK? Maybe. So legally, the UK police is obviously not able to exercise their jurisdiction within the territorial confines of the US. And so the UK can't send their police agents over and arrest her in the US. And it's possible that the statute of limitations for this particular crime, which I'm not sure if that would be reckless endangerment or maybe vehicular manslaughter, would extend long enough. So it's possible that she could go back after that statute of limitations had expired, at which point the UK police would not be able to carry out the process of justice. The other important question is, can the US instead prosecute her? And the answer is almost definitely yes. Will they? Probably not, but can they? Yes. And that's because of the active personality principle, which says that any state is entitled to prosecute its own citizens for crimes committed anywhere in the world, provided, of course, that this is already set in the US Criminal Code. This, of course, creates the question of, well, why the hell do we even have these immunities in the first place if they're being used for this sort of frivolous stuff like protecting people from driving on the wrong side of the street, or being prosecuted for driving on the wrong side of the street? Well, that's because the intention of the convention is to protect the sending state, where you don't want a potentially hostile or semi-hostile receiving state from arresting or detaining either the diplomat, him or herself, or his or her family, and then using them as leverage to force the diplomat to sign documents or to make decisions that would be harmful to his or her state. Now, of course, anyone who has been in New York, especially around the UN, knows that there are a lot of people out there who do misuse these protections to gain immunity from a wide variety of traffic violations, up to and including this sort of reckless driving. But if we were to remove that, then it would put everyone at risk, and it would create the possibility, no matter how remote, and it would not be a remote possibility, of maybe not people being arrested, but people being under the threat of arrest or detention, and that being used as leverage to put the sending state of these diplomats in a highly disadvantageous position, which would not be consistent with the principles of international law. And of course, there is supposed to be a check on this right, and that's the waiver. And it's right there in Article 32. 32 says two things. Number one, the sending state is always able to waive the immunity of any of its agents, but also says that this waiver must be express. The immunity from jurisdiction of diplomatic agents and of persons enjoying immunity under Article 37 may be waived by the sending state. But what's important to remember is that this is not an obligation required of the sending state. It's actually just a discretionary right. And if a state does not choose to exercise that right, then under international law, there is nothing that the receiving state can do to provide justice to the victims of a crime. Now, of course, there are a couple of other means available. I would assume that she's probably banned from the UK, or will be once the statute runs out. It's also possible for the receiving state to declare an individual to be a persona non grata, which means that after a reasonable amount of time, the immunity runs out because the receiving state has declined to give permission for that person to be in their country. And of course, no matter how strong these immunities are, there's no way that it can trump the territorial right of the receiving state to choose who comes in and who does not. But in this case, the driver fled the country before she could be declared a persona non grata, and that would not be an issue in this case. And so, while it sucks to see these kinds of stories, and to see such flagrant abuse of the right of immunity, there isn't really too much we can do about it without putting the entire system at risk. We have to have faith that in most cases, the sending state will waive immunity where it's right to do so, and will use that discretionary right in a way that is also morally right.